welcome to everybody to this fourth session. We're going to be looking at statutory and contractual adjudication. As Sean said, my name's Jess Tresham. I'm a construction partner at Womble Dickinson, and I will be chairing today's event, and we're very fortunate to be joined by our international panel of experts who are going to be providing us with their insights on the differing approaches of their respective jurisdictions. So in terms of how this session will go, we're going to have a series of 6 short presentations. Please feel free to use the chat and Q&A applications if you've got questions to ask. I will try and deal with them either at the end of a specific talk or if we're running out of time at the end. So we're going to start today with Peter Clyde, who's from Addleshaw Goddard. Peter's a legal director and he specialises in construction engineering and infrastructure and energy disputes. Now, Peter's going to give us his thoughts on mandatory mediation in England and Scotland. And also, we're going to talk a bit about mandated alternatives to adjudication. So if I may hand over now to Peter to kick off with his views on that topic. Thanks, Peter.
Thank you very much. Okay, so I have 2 submissions I want to make today, both of which I currently agree with, maybe not tomorrow. Such is the lawyer's life. The first one is mediation should not ever be mandatory. And the second one is dispute boards should be a statutorily approved alternative to adjudication. So let's start with the easier one, mandatory mediation. Mediation is the second most popular way of resolving disputes, both in the UK and globally. That's according to the latest Arcadis disputes report. So I read an article late last year by a major law firm, and it was suggesting that mediation should be introduced statutorily as a first step before recourse to adjudication. So I want to explore that suggestion a bit today. Mediation is strongly encouraged in the UK, both in England and in Scotland. The court can impose sanctions for an unreasonable failure to mediate. CPR 44.4 in England allows for that. And there's been a recent spate of decisions along those lines. Gregor Fiskin and Carl, it was described as highly unsatisfactory in the Court of Appeal, the unreasonable failure to mediate. The first instance judge having strongly encouraged it. And of course, in some forms of contract, mediation is a mandatory early step in the dispute resolution process, albeit where the Construction Acts apply, it can't impinge upon immediate recourse to adjudication. So in Scotland where I am, there is more encouragement for this idea of statutorily mandated mediation. In June 2019, a report was published by Scottish Mediation, who I suppose are not unbiased, who recommended introducing a degree of compulsion into the system to encourage parties to consider mediation. Its recommendation was, where mediation is appropriate, parties should be required to attend a mediation session before their court case can proceed. And by mediation session, they mean a session to help parties understand what mediation is and why it can be useful for them. And they want that requirement and the exceptions to it backed by statute. So I've got 2 issues with mandatory mediation. The first one is that mediation works best when it's approached at the right stage in a dispute. In brief summary, it's when both parties know their cases, they've had it tested, perhaps by an expert and by their lawyer, they know its weaknesses, they perhaps know the most likely outcome in a tribunal. So if it is to be mandated, contractually or statutorily, it should not be forced at too early a stage, as it often is contractually, to make it most useful. And secondly, when mediation is voluntary, the very act of agreeing to mediate signals a willingness to compromise, perhaps significantly. And if mandated, you might lose that. Attendance may be for one party little more than a tick in the box and an avoidance of sanctions. It does quite little or much less to aid settlement. On this basis alone, I say, don't mandate mediation, or you remove one of the most powerful aspects of it. The article I mentioned from the law firm also suggested that a mandatory requirement should be introduced to speak, for parties to speak ahead of any adjudication. So less than mediation, but to at least have some perhaps face-to-face contact. And actually, that's probably a very sensible suggestion, because often adjudications, on the door of adjudication, all negotiation and discussion goes out the window perhaps too early, because the parties have got such short timescales to turn around their arguments. So in that regard, the UK Construction Act's ban on any obstacle being put in place in adjudication is a rather blunt tool in that regard, and ripe for change. So that brings me to my second suggestion, and it is this, that the UK Construction Acts should recognise dispute boards as a viable alternative to adjudication, or at least to the 28-day adjudications as we know it. And I say this because, in my experience, more often than not, adjudication does not achieve a just outcome. Okay, strong statement, especially in a conference attended by lots of adjudicators, hosted by an adjudicator nominating body. So let's test it. Let's take justice as meaning giving each party what he or she deserves. And let's assume that the law of your jurisdiction, the correct legal outcome of court proceedings, will be the just outcome. In other words, parties will get justice, they get what they deserve only when the legally correct outcome is achieved. In 2019, we surveyed with Glasgow Caledonian University the UK adjudication industry, and one of the questions we put to them was exactly this. And a significant number of recipients considered that adjudicators did not tend to come to the correct outcome, the legally correct outcome. It's trite to say it. You ask any senior barrister, what do you think about adjudication? In fact, anyone I've asked, they slot into the usual refrains. It's rough justice, it's a lottery, it's a bit of a carve up, and they like to find something to strike out. This has become absolutely standard practice when discussing adjudication outcomes. In other words, reasonably often, an adjudicator will not come to the legally correct, the just outcome. Our survey recipients were much more likely to consider that adjudicators reached a fair rather than a legally correct decision. But I would argue that this concept of fairness, as commonly applied to adjudication, is skewed. If something can be fair but not legally correct, the assumption is that the legally correct outcome may be unfair and that a bit of a carve-up achieves greater fairness. That cannot be correct. So when we speak of fairness in adjudication, I think what we really mean is compromise, which makes adjudicators in some instances more akin to mediators, finding the best compromise between the parties rather than the legally correct outcome. And that is not, I propose, how the legal system is supposed to work. So the question then is, why do unjust outcomes result? And I think there's probably a few reasons, but the main one, the one I want to focus on today for time, is the absence of a formal court procedure. Adjudication, by its very nature and the length of it, skips a great deal that is necessary in finding the finely tuned, legally correct outcome. There is often no cross-examination of witnesses, which is vital to reveal flaws in witness testimony. There is often no oral presentation of arguments, and with it, the easy ability for a decision maker to sense check their understanding. So what has all this got to do with the topic at hand, that of mandatory ADR? Well, it seems to me preferable that with this in mind, adjudication ought not to be mandatory for every project or for every dispute. But parties ought to have recourse to a procedure that's quicker and cheaper than court, but more structured and by default more involved than adjudication as usually practiced. And in my view, one alternative is to encourage the greater mandatory use of dispute boards in a domestic UK context. Of course, this mechanism for determination by dispute board is already prescribed into some contracts. In my view, standing dispute boards tend to work less well, but ad hoc dispute boards, and particularly those which take the form of a mini trial, let's say 100 days from start to finish, some degree of advocacy, of cross-examination of witnesses. To me, this hits the sweet spot for, yes, a typical cross-border dispute that's complex, but also a large-ish complicated domestic matter. It gives the client significantly more cost and time certainty than full arbitration or court, but inspires more confidence that each issue is going to be properly tested and adjudicated upon. And we're already seeing dispute boards being contractually mandated on very large domestic projects. My suggestion in closing is that their mandatory contractual use should be encouraged more widely across a wider range of domestic products. And it needs to be done statutorily because at the minute, whatever you put in your contract, whatever a great dispute board process is drafted in, if you're a UK domestic contract, all of that can be entirely thrown out the window with immediate recourse to adjudication. So in my view, there should be this statutory recognition that there is an alternative, perhaps a better alternative for some of these projects, and that should be statutorily recognized. So that is my time up. So I'll hand back.
Thank you, Peter. That was really interesting. One thing that sort of struck me is that in my experience, and I'm sure many of my colleagues on here will agree, is that, you know, the mediation procedure or ADR procedures generally can start to become a bit like a litigation look-alike, and you soon find that the costs of that ADR begins to sort of start to approach the cost of litigation. Do you think a statutory regime would actually change this, or do you think we'd just end up front-loading our litigation with ADR type mechanisms that parties are obliged to comply with, and in the event of no settlement being reached, for example, in the mediation process, the parties have already spent a considerable amount of money? Just be interested in your thoughts on that.
In my view, mediation can get overly complicated, but it doesn't have to. I've never had a mediation that has cost anywhere near the average adjudication. There's ways to limit it. You can limit it in time. Mediations that span more than a day for more than all but the most complicated things are probably going too far. You know, and I think probably even the active position papers, you're right, can take a lot of money and not get you much further forwards because you've known it all for some time. So I think you do need to put structure in place around it. It's also very difficult to mandate mediation statutorily because you can't force compromise. So again, you're sort of just putting a tick in the box, which, as you say, could cost 30k and do little to get you any closer.
Yeah, no, I would agree with you there. In the interest of time, I think we'll move on to our next speaker, which is Albert Yu. And Albert is a senior resident engineer at AECOM and is based in Hong Kong. Albert specialises in commercial and dispute management and is an operating member of the Hong Kong Institute of Construction Adjudicators. And in Hong Kong, there's a very different approach to perhaps that we experience in this jurisdiction. And Albert's going to talk a little bit about the security of payment legislation adjudication scheme. So moving over to Albert now, please do share your thoughts with us. Thank you.
Okay, thank you, Jessica. Right, so I'm going to briefly talk about the Hong Kong SOP legislation, security of payment legislation, followed by John, who will be talking about the contractual adjudication that the Hong Kong policymaker is going to implement very shortly. And that's the decision by the Hong Kong policymaker in lieu of implementing the SOP legislation. They are going to start to launch as a trial by implementing what we call the SOPL spirit in public works contract. So that is the first step that the government is going to implement fairly shortly in the later year. Okay, and then we'll have Glenn, who will be talking about arbitration in contrast of statutory and contractual adjudication. So a little bit about the background of the SOPL. So before the government, they studying the possible implementation of the SOPL. In Hong Kong, we have the traditional dispute resolution clause in public work sector and in private form, in the form of multi-tiers dispute resolution clause. So normally when there's a dispute arising in the construction contract, it normally goes to mediation and then to adjudication and arbitrations. But some of the standard form, we do not have adjudication. So when the parties do not agree to go to mediation, they escalate to arbitrations. So a little bit of background about the development of the SOPL in Hong Kong. In 2001, we have the 10th report realizing the cash flow problems in the construction industry, and there was some survey carrying on since 2011, and until 2015, the government has implemented a public consultation document on the SOPL, and they have different questions based on the framework of the SOPL from different jurisdictions, and they put the questions to the industry stakeholders, and they collect the answers, they analyze the feedback, and they publish a document in 2016, the report of public consultation on the SOPL in the construction industry. And from then on, the policymaker, they were drafting on the bills, the SOP bill, but up to date, they have not put it through the legislation council. And what we have heard that is from the earlier of this year, the policymaker, they're going to first, they put through the proposed SOPL spirit in the form of contractual adjudication in public works contract. And we've heard that this will be published shortly, probably in next month, for all the public works contract in the government sector that is going to be tendered in the later years. So some of the issues that was discussed. So basically in the consultation paper, they put questions to the industry stakeholder. They're from different backgrounds, from professional associations, different construction companies, from the contractors, subcontractors, and suppliers company. And there were also individuals. They have collected feedback from all the parties, and they analyzed based on the statistics, and they published the report on 2016. So there's some of the issues that I want to share with you. Is that the first one is whether the SOPL shall be governing on all or partly all contract, and we can see that a majority of the respondents they prefer to have the SOPL to cover the oral and partly oral contracts. And the application of SOPL, basically, the government is proposing it to be applied in all the public works contract irrespective of the project values. And in the public sector, in the private sector, the SOPL, they're proposing it to govern only on new buildings based on the building ordinance in Hong Kong, with the original contract value that's more than 5 million, and also 0.5 million for professional service contract and supply contract. So that means engineering contract, architects contract, and QS contract. Definition of construction contract, basically is contract for all construction activities including service contract relating to architectural design, quantity surveying, engineering design. It also covers a supply contract for material, time, and material labor in connection with construction activities. And it also covers construction activities carried out within Hong Kong. In Hong Kong, we normally have a construction project where we might have a precast unit. We have some activities, construction activities that's carried out in the mainland China. So I think it has to be clearly specified whether the SOPL will only cover for all the construction activities in Hong Kong or partly carried out in Hong Kong. Exceptions for value contract in private sector. So these are the two exceptions. I think the government, they're going to implement the SOPL in all the public works contracts to start with, and then later on expand it to the small value contract in the private sector. Inclusion of disputes. So basically for work done, material cost in a payment claim, it relates to payment claim, set off and deduction against the amount due under payment claim, and EOT in relation to payment. So if there is a dispute on EOT and liquidated damage dispute, that might be covered by the SOPL. Some maximum period in relation to payment, 60 calendar days for interim payment and 122 calendar days for final progress payment. So that's the default payment period if it is not specified in the contract. So parties are entitled to claim the progress payment every calendar month. The methods of reference date is not included in the SOPL, but it is now included in the SOP spirit in contractual adjudication that is going to implement in later this year. Value of work done is based on any contract rates agreed or in the market rates. So that is basically what the adjudicator has to determine based on the SOPL framework. In terms of timeline, what the SOPL is proposing is to have a payment claim followed by a payment response within 30 calendar days. And then after that, the parties has 28 days to initiate the adjudication, followed by the appointment of adjudicator by an AMB, adjudicator appointing body. So it depends on the policy of the AMB, might be less than 5 working days. Follow that the claimant issue a payment claim on the same day, adjudication claim on the same day as the appointment of the adjudicator, and followed by 20 working days, the respondent submitted an adjudication response to the adjudicator and the claimant. What's different here is we do not have the adjudication reply like in the Malaysian model. After the adjudication response is served, the adjudicator decide the adjudication application within 20 working days. So that's basically the timetable in graphical forms. The adjudicator has 20 working days after receipt of the respondent submissions to render a decision, but that is extendable up to 55 working days by the adjudicator, and then by agreement between the parties over about 55 working days. The issue on failure to serve a payment response. So the industry feedback is that they generally agree that the respondent is unable to raise a set of claim against the amount payable due in the payment claim if it's not raised in the payment claim. That's another controversial area about the AMB. So what's the policymaker is proposing that if there's no agreement on the AMB, the Hong Kong institution, the Hong Kong International Arbitration Center will become the default AMB. But the industry response is there's a split response. So basically there are 49% agree and 48% disagree with this arrangement. So there are other professional bodies like the Hong Kong Institution of Engineers, Hong Kong Institution of Architects, and Hong Kong Institution of Surveyors. They are professional bodies that are competing for being the default AMB under the SOP legislation. Pay when pay clause that basically follow other jurisdictions that are having the SOP legislation. That is the provision that makes the payment conditional on payer receiving third-party payment is ineffective. Conditional payment on the operation of other contract of agreement is also ineffective. Right, for a non-payment, the SOPL is proposing two scenarios that a suspension for the right of suspension for non-payment will arise. The first one is the when the payment, when the respondent agree to a certain part of the payment claim in the payment response, but the payment is not paid within the due date. The second scenario is when the adjudication decisions ruling is not followed by the respondents. That means the adjudicated amount is not paid within the due date, before the due date, and the right of suspension arises under that two situations. That's slightly different from some of the Australian jurisdiction where I remember that there's a third situation where the right of suspension might arise is when the payment is due under the contract in the first place before the adjudication was initiated. So that's the third scenario, the situation where the rights of suspension may arise in the Australian jurisdiction, but just not proposed in the Hong Kong SOP.
Thanks, Albert. I'm going to have to hurry you along, I'm afraid, because we're not going to get to all of our great speakers today. So if you don't mind, just closing up. Thank you.
That's about my last slide. So resuming works upon suspension that I think has to be clearly specified in respect to whether EOT and costs during the period of resuming work should be borne by the claimant, and that's not quite very clearly specified in the SOPL proposal. So I think I'll stop there and I'll let John to continue with the part of the contractual adjudication.
Thanks, Albert. We'll move quickly on to John, who is an architect, an arbitrator, accredited mediator and adjudicator, and he's going to talk to us a bit about the proposed contractual spirit of the SOPL adjudication scheme. So thank you, John. I shall hand over to you. If you can stop sharing your screen, Albert, that'd be great. Thanks a lot.
Thanks, Jess, and thanks, Albert, for the intro. So let me just share the screen here. Now I've got some slides. I'm not going to try and go through them all in any detail, but I understand that they will be shared afterwards so people can look at them for a little bit of extra info if they want. So I'm going to share this screen. Hopefully everybody can now see that. So statutory or contractual ADR and Hong Kong government's spirit of SOPL scheme. What's this all about? Well, Albert gave you a little bit of an introduction to it there. As he told you, we've only had since 2001, when the Tang report was issued, to think about adjudication in Hong Kong, and we've only actually been actively working on the legislation since 2011. So obviously that's not long enough to get statutory adjudication in place. And so to solve that problem, the government's decided to introduce basically equivalent provisions as part of their contractual scheme for public works. So this is driven by, as Albert said, the policymakers, which is the Development Bureau of the Hong Kong government, under which all of the works departments are operating. So that's Architectural Services Department, Civil Engineering Development Department, water supplies, drainage, all of these highways, all of these departments. And the intention is, and this came out essentially because, as Albert mentioned, there was consultation on the SOP legislation. Really, that hit a bit of a stalemate in the consultation with the industry regarding various issues. And so earlier last year, this idea was floated about having the spirit of SOPL incorporated into the public works contracts. So there was a technical circular circulated in March of this year. Consultation on that closed in April, and we're now just basically waiting for it to be implemented. Now, the current timetable is that the adjudicator nominating bodies are currently open for application. There are 4 potential bodies, as Albert mentioned. Arbitration Centre being one, HKIAC, and then the Institutes of Architects, Engineers and Surveyors. So that will finish at the end of the month, at the end of August. And then the hope is that it would be implemented and released to the market, the final version of the, or the final draft version, so that it would be actually operating, hopefully by about the end of this year in new contracts. So the intention is that it will apply immediately from the date of issue of the technical circular. As it says on the slide, that was originally intended to be as early as this month, but it's not going to be quite that early yet. And it's going to apply until the legislation is put into place. And the idea is that the contractual scheme will allow government to get feedback on the process, which they can then feed into the Legislative Council as a way of massaging or honing the legislation, and hopefully helping to convince the Legislative Councillors to support the motion. Whoops. There we go. So there's the objectives as stated. I won't read them out because you can look at them for yourself, but those objectives obviously parallel the sorts of objectives that are stated by legislators all over the world who've been introducing security of payment legislation. The scope of this is essentially all public works contracts under Development Bureau. So that will be all infrastructure, building, and in fact, including consultation or consultant agreements, and including things like maintenance term contracts, repair contracts, and those types of things, and also including service and supply contracts. Hong Kong government basically works under 2 broad categories of contracts. That's the general conditions of contract, for which there are versions for building and civil works, and under NEC. And the conditions of contract are, or this scheme is going to apply under all of those contracts. So the mechanism is by incorporating either special conditions or additional conditions, depending on whether you're talking about GCC or NEC, into the main contracts. And as part of that, there will be a set of mandatory subcontract conditions, which the main contractor will have to then ensure get incorporated in the subcontracts all the way down the line. That's going to then be enforced by government, by things like technical audits on site, promoting it directly to subcontractors on site, requiring main contractors to report on their subcontractors, including the SOP situation, and reflecting the results of that, importantly, in the contractor performance reports, which is actually what contractors in Hong Kong are mainly working for, rather than just money. So I don't think I need to go through these next couple of slides in much detail, because essentially what government has done is taken the statutory or the proposed statutory scheme as it's being currently developed, tweaked it a little bit to suit themselves, and then mandated that into the contracts. So as it says here, it's got some 4 mandatory requirements. These, of course, apply to the subcontracts because the government's own requirements will be incorporated directly by them in their own main contracts. They don't have to worry about making things mandatory or optional there because they control it. But for the subcontracts, they're mandating these 4 mandatory requirements, which I'm sure everybody will recognise from any set of security of payment legislation. And then they're also providing various other provisions, which are sort of default provisions, which will apply unless other more stringent provisions are agreed within the subcontracts. So again, that then carries that through. Now, the next slide here covers what is the bone of contention, which is extension of time. And this is really where the legislative discussions broke down, because the scheme as it's proposed is a payment notice and response type scheme, like they have in, for example, New South Wales and Australia. So it's very limited in scope. The proposal was that adjudicators ought to be able to decide extensions of time, and the compromise position which government has put forward is what's shown on the screen there. Essentially that adjudicators will be empowered to determine extensions of time to the extent that they relate to payment claims. Those extensions of time will be binding and enforceable, but only on an interim basis, like for payment. But a party will not be liable for liquidated damages if the works are ultimately completed within the EOT, which has been decided by the adjudicator. And I think it's probably fair to say that it's this provision that has, or this set of provisions, which has generated most of the discussion in the industry and probably provides most of the areas of uncertainty that will need to be worked out when we see how the scheme rolls out. Further provisions, again, this is about subcontracts. This is really just mechanisms to government, or that government have incorporated to allow them to impose a stick on the main contractors to make sure that subcontractors are incorporated into the system and that they can get their payments. And that includes, importantly, the second bullet point shown there, which is that subcontractors who have an adjudication decision which has not been paid will be able to apply directly to government for payment. So the end slide, and I have no intention of trying to answer these questions because A, I don't have time, and B, because I think that they can't yet be answered. But I think these are the sorts of things that we as an industry are currently looking at and will need to look at. Things like how is the enforcement going to work in practice, because enforcement, importantly, is purely enforcement of a contractual decision. And so the way to enforce it is to sue on the contract. And that raises all sorts of issues. And I see, Jess, my time is up. So I'll hand back to you. Thank you very much.
Thank you there, John. That was really interesting. And just to sort of conclude our trio of perspectives on this, I'm now going to hand over to Glenn, who's a partner at Bryan, Cave, Leighton, Paisner, and a solicitor in Hong Kong. Brian's going to, sorry, I beg your pardon, and Glenn's going to look at the proposed schemes that Albert and John have just talked about in some detail and look at the comparison with adjudication. In light of our time pressures, I won't talk anymore, and I will hand over to Glenn to tell you what you need to know. Thanks a lot, Glenn.
Okay, thank you, Jess. I have a set of slides, but I won't put them up on the screen because, out of fairness to Yasemin and Johan, I'll give you a real whistle-stop through the comparison of the statutory and contractual adjudication schemes in Hong Kong and arbitration. But if I could start by saying that Hong Kong, don't believe what you see on CNN, BBC and MSNBC. I've lived and worked here for 30 years. I love the place. Hong Kong's open for business. It's safe to visit, it's safe to work in. And so we have a common law system here, and we'll have it until 2047. Rule of law is strong here. we have a good independent judiciary, we have a large pool of talented and independent mediators, adjudicators, and arbitrators. As a jurisdiction, Hong Kong is pro-arbitration, and the courts demonstrate that, pro-enforcement of arbitration awards, and it's been government policy for a long time to be a pro-mediation as well. But also Hong Kong traditionally has been a free market economy, low regulation, and freedom of contract, party autonomy. And so interestingly that both adjudication schemes, both the contractual and the statutory, of course, are going to do some violence to that low regulation and freedom of choice. And I think partly that's been the author of what John was talking about, the resistance from various parts of the industry to the adoption of these schemes. So the statutory scheme has been bogged down, stalled for ages. That's part of the reason why government wants to try to kickstart it with this contractual scheme, which, although it's contract and you have freedom of contract, it's going to be imposed on the parties so that hopefully members in the industry can see that adjudication isn't really such a bad bogey thing that they should be scared of, but it's good overall for the industry to get the dispute resolved quickly and to get that money flowing down the contractual chain. As for arbitration, Hong Kong is a model law jurisdiction. We implemented a new arbitration ordinance a few years ago, and it is model law. Now, we have a few exceptions to that, but it's largely model law. We have an opt-in scheme for a couple of extra challenges you can make, but otherwise arbitration awards can only be challenged on those very limited grounds that are set out in the New York Convention, with which you'll all be familiar. So as I said earlier, and as everyone knows, arbitration is consensual. The parties agree or not. The statutory adjudication scheme, once it's implemented, that will not be consensual if you fall within the scope, as outlined by Albert and John. As I adverted to earlier, the contractual scheme, although parties have to sign contracts, effectively, if you want to do public sector work in this trial, you will be part of, and if you fall within the scope, you will have to adopt the contractual scheme as part of the contract. And so government will enforce it in the main contract through the contractual provisions providing for adjudication, and will include in the main contract contractual requirements for the main contractor to have similar contractual adjudication scheme provisions in all of his subcontracts, and to take steps to try to ensure that all subsubs have the same scheme further down the chain. So it's contractual, which is consensual, but it isn't really, because if you want to do the public sector work, you'll be using this contractual scheme. Arbitration, of course, can exist happily with a tiered scheme where you have the decision of the certifier followed by mediation often, then maybe adjudication up to arbitration. And arbitration in Hong Kong, we're happy to have the tiered schemes. It seems from what we've read that both the statutory scheme and the contractual scheme will take away all rights to the tiered processes if any of those are going to be an impediment to the right to go to an early adjudication decision. Although in the contractual scheme, I think that they have left alive if it's a tier that is part of the decision-making process, which perhaps is the usual one that you refer it to the certifier for the first decision. But that is still to be seen. Then quickly on to enforcement and challenges. As I said, arbitration is very clear, very limited grounds to challenge an arbitration award in Hong Kong. It's those limited grounds in New York, and Hong Kong has shown itself to be pro-arbitration, pro-enforcement, isn't very interested in challenges under the New York Convention and will order indemnity costs when the challenge is unsuccessful. Schedule 2 to our arbitration ordinance, you have to expressly opt into it, but it allows challenges, if you opt into it, on serious irregularities, similar to your 96 Act in the UK, and also appeals on questions of law where you have to get leave to appeal first and then go. As for adjudications, as both Albert and John said, it's unclear exactly what those grounds are going to be. But in both schemes, there's the usual thing where the decision of the adjudicator will be interim binding and must be complied with. You can challenge, you'll go to court under the statutory scheme, and it's a rehearing by the judge that hears it rather than an appeal. Under the contractual scheme, you'll challenge it under the dispute resolution procedure. If you have an arbitration clause, you'll go to arbitration. But it's binding, the decision's binding in the meantime. The extent to which the other types of challenge, similar to the ones you see in the UK about if there's an excess of jurisdiction, if the arbitrator, if the adjudication clearly has answered the wrong question, or if the decision is just so crazy that it couldn't be right, fraud, bias, the extent to which those challenges, we're having a real debate about those. So it will be watch that space, because we haven't seen the legislation yet, and the contractual scheme still has quite a bit of fleshing out. So that's my whistle-stop tour. Hand over to Yasemin and Johan. I hope I've left you a bit of time. Everyone, please visit Hong Kong. Thanks, Jess.
Thank you, Glenn. And thank you to the speakers so far, and in particular, interesting reflection on procedures in Hong Kong. I'm going to hand over now to Yasemin Cetinel, who is the founding partner of Cetinel law firm. Yasemin specialises in construction law and represents and advises contractors across various nationalities. Yasemin's going to give us an insight from Turkey, approaches to ADR methods, and look at adjudication, and also focus on whether there's a place for a statutory procedure. So without further ado, I'll hand over to Yasemin to share her thoughts with us, and thank you very much.
Thank you, Jessica, for the kind introduction. Hello, everyone. It's a pleasure and honor to be here today among these very distinguished colleagues, panelists. So as Jessica stated, I'm a construction lawyer based in Turkey. So my speech will be from the construction law perspective. And I will be aiming to provide you with some insights from Turkey and some further insights from the MENA region. To put the issue in context, I would like to start with some numbers. And in terms of construction sector, MENA region deserves some attention. According to Arcadis 2021 report, the average value of construction disputes in the region is 86 million United States dollars in 2020, which shows a substantial increase in comparison with the recent years, and the number of reported disputes have also increased. These are important data from the region. And we also saw and noted that adjudication is not within the top 3 rankings of the ADR methods. In MENA region, it is the first ADR methods in the list is the party-to-party negotiation. The second one is arbitration, and the third one is mediation. Now, Turkey is an active and comparatively big player in the region as well. So, with widespread investment through the contractors in all around the region, basically. And therefore, some data about Turkey could be very useful too. So in Turkey, construction industry accounts for nearly 8 to 9% GDP, employing almost 2 million people. And with the direct and indirect impacts, share of the construction sector in the economy is around 30%. And lastly, Turkish contractors within the period of 1972 to 2020 have undertaken more than 10,000 projects all around the world, and specifically in 128 countries, with a total value of 418.7 billion US dollars. So these numbers demonstrate that the construction disputes are the leading disputes when it comes to ADR methods as well, including arbitration in Turkey. Now, with these data in mind, I would like to give a brief overview of the ADR legislation or legislation related to ADR. First of all, we have International Arbitration Act since early 2000s, and domestic arbitration legislation even predates the International Arbitration Act. However, as you may all be aware, having relevant legislation does not mean an established practice. It is only by recent established case law, and this case law concerned the policy against annulment of arbitral awards and against parallel cases, whereby there is arbitration clause, but domestic courts nevertheless accept their jurisdictions, which results in parallel cases. So it's only recently that we have established an arbitration-friendly legal environment in our country. However, we are discussing about construction disputes, and we all know that arbitration is not and should not be the only legal remedy, and there should be alternative methods applicable to the projects. So my panelists discussed quite heavily about mediation. On mediation in Turkey, we have regulated codes and jurisprudence. And indeed, in the last couple of years, mediation became a mandatory pre-court stage for commercial disputes. So referring to what Peter has said about mediation should not be mandatory, Turkey seems to have done exactly the opposite. And in my personal opinion, when it comes to construction disputes, mediation may not be in all cases the perfect solution. So we have arbitration, we have mediation regulated, and we have a third option, which is not at all almost practiced in Turkey, which we may call as a lawyer-involved protocol, which we may describe as when parties agree on an amicable settlement protocol. In order to make such protocol enforceable, like an arbitral award or a mediation protocol, both parties' counsel should sign such protocol. And in the moment such signatures are obtained, you have an enforceable document. And this is regulated under our attorney's code, but unfortunately, we do not have this implemented in practice. So with all these things in mind, I should finally note that there is no statutory adjudication or any legislation in terms of concerning dispute boards in Turkey. Hence, the adjudication and or dispute board concept is purely a contractual mechanism currently in Turkey. And it is used mostly in internationally funded projects where the funders are requiring FIDIC forms of contracts to be put in place, and accordingly dispute boards also to be put in place. So this is the current situation, but I should conclude with some consideration for future and or better practice of the boards in Turkey and also in MENA region. In my belief, and I keep on saying this in several conferences as well, the most important component of the dispute board concept, conditio sine qua non, in other words, is the trust and the respect they create in the parties towards their expertise. So what I mean by that? it is because once you obtain as a board member the party's trust, the resulting product, which may be in the form of an opinion, which may be in the form of a decision, will be respected as well. And the ultimate purpose of the whole concept of the dispute boards and or adjudication is basically the enforcement of any product, which is the outcome of the concept. So when you create this trust in the practitioners, in the parties, you indirectly create the enforceability of the said document as well. And it is mostly put into use in amicable settlement negotiations that may follow such dispute board product. And accordingly, parties have a very respectful tool that they will use in the prevention and or resolution of the issues they may have in their construction projects. So, and I also say that unavoidably, the linking element is the creation of the trust. And how you create the trust is another important question for me. And in my opinion, again, it is only created by skillful and expert people in their fields, which can conduct the process efficiently. And it comes by the conduct of the process and also by the rightful appointment and selection of the dispute board members, the adjudicators as well, in order to reach this trust and respect solution. So to conclude, statutory or contractual, I think the most important component is the trust, and hence indirectly this is more well established in standing boards, and indirectly again I would probably conclude that the statutory adjudication may not at least be the only legal remedy to use for the best industry practice for the dispute board concept. So I should give the floor to Jessica with these in mind.
Thank you, Yasemin. I think in terms of questions, we've got quite a few coming through, but I'd certainly like to give each of the speakers an opportunity to fill their slot. So for the moment, we'll hand over to Johan Beyers, who's a member of Keating Chambers. He's been an advocate in South Africa for more than 27 years and specialises in domestic and international arbitrations, amongst other matters. Johan's going to talk to us a bit about the South African perspective, and I'll pass over to him now. Thanks, Johan.
Thanks very much, Jessica, and afternoon, everyone. I'm going to shortly run through the status of adjudication as it stands at present in Africa. As a point of departure, adjudication in Africa is a creature of contract, not statute. There aren't any statutory adjudication schemes in any African country at the moment. There was an attempt to introduce it a couple of years ago in South Africa, but the draft regulations were never ultimately promulgated. But nevertheless, despite the presence of an adjudication statutory scheme, it has been a feature of large African construction projects since at least the late 1990s. And this is mainly due to the role of the World Bank and FIDIC. The World Bank is a major funder of large infrastructure projects in Africa, and it favors the FIDIC suite. In 1995, the World Bank introduced adjudication as a funding requirement, and FIDIC introduced adjudication in the form of a dispute review board process into its standard forms thereafter. It adopted initially the American model of a non-binding adjudication decision purposed to foster settlement between the parties, and the board was a standing or ad hoc dispute board. I encountered this, for example, in the late 90s on the Lesotho Highlands project, where DRPs were appointed on all of the contracts in that project or in that scheme. In 1999, the FIDIC suite introduced the dispute adjudication board process, and the difference here was that the decisions were now binding pro tem, pending final determination on arbitration. And FIDIC has retained this dispute adjudication board structure in its latest revisions from 2017 onwards, albeit the dispute adjudication board is now called the Dispute Avoidance Adjudication Board. In South Africa, there are a couple of standard forms that are used, and a few are approved for government procurement. The FIDIC, which has always been a popular choice for large South African infrastructure projects, for example, the Medupi and Kusile power station projects at present use the FIDIC form. The JBCC form, which is a building contract originally based on the JCT form, it probably was probably used in about 80% in number of all projects in South Africa, but obviously not 80% in value. The GCC, General Conditions of Contract, which is published by the South African Institute of Consulting Engineers. It's a form for civil engineering works, probably a main competitor to FIDIC in South Africa as far as forms go. And then the NEC, which is used in South Africa, but it seems lately less frequently on infrastructure projects. There's for professional service provision on all projects, the CIDB publishes a standard professional services contract. Now, in 2004, the JBCC and the GCC introduced contractual adjudication. It introduced it in the form of a binding decision pro tem pending arbitration or litigation, and it has retained that since. The Construction Industry Development Board prescribed adjudication for government procurement projects in its best practice policy document in 2005. And of course, under the NEC form, contractual adjudication has always been available as an opt-in option. And where it is used in South Africa in government projects, the NEC form opt-in option for contractual adjudication is normally present. In the case of the standard professional services contract, it offers a choice between adjudication and mediation. And for some reason, I guess because the parties value the retention of their relationship in the case of professional services supplies, mediation is usually preferred by employers. There's very strong support for adjudication in South Africa from the South African courts. South African courts enforce adjudication decisions very robustly, whereas established grounds for opposing enforcement have developed in the UK, for example, on account of lack of jurisdiction or gross procedural irregularity. South African courts have resisted the establishment of grounds to prevent enforcement of an adjudication decision. And the approach is that complaints about the validity of the decision should be addressed in final dispute proceedings, in arbitration or litigation, and not at the enforcement stage. The consequence of this approach is that adjudication in South Africa is extremely effective. The only downside is that it may take up to 6 months to obtain an enforcement order simply because the court rolls are quite congested. Now, there are advantages to a contractual scheme. Parties can introduce an adjudication mechanism and procedure that suits the specific project at hand. And the robust approach of the South African courts to adjudication in South Africa neutralize attempts by defendants to undermine the adjudication process with technical objections. The disadvantages of contractual adjudication in South Africa is that there's a much narrower application of projects and contracts, or contracts to which it applies. It's a contractual scheme, so the contract needs to provide for it. And the usual matrix in construction may involve 150 or more project participants and numerous one-to-one contractual relationships, and not standard practice in South Africa to provide for adjudication where a non-standard form is used. For example, a contract between a subcontractor and a supplier would usually not have adjudication. Even where you have the main contractor versus subcontractor contracts, even there, often, if a standard form is not used, adjudication will be absent. And this means that the more vulnerable project participants who need it most are often not able to benefit from adjudication. And if you look at the number of contracts that are involved in a particular project, you may have 70 different contracts between employer, contractor, subcontractors, and so on. You may find that only the top tier 3 or 4 contracts actually provide for adjudication, and the remainder don't. Other disadvantages of contractual adjudication is that the availability and efficacy of the adjudication process is dependent on the quality of the adjudication clause. Courts are not able to support an adjudication process other than through an order for specific performance. It can't write a contract for the parties. So clauses that, for example, inadequately provide for the appointment of an adjudicator or the adjudication process itself, or for the effect of the decision, may result in a failure of the clause as a whole. Fortunately, the standard forms in South Africa generally incorporate one of several sets of rules published by various adjudication bodies as a default position, and this tends to fill gaps where the party's adjudication clause falls somewhat short. So perhaps in summary, contractual adjudication has successfully operated and does so in large African projects for more than 20 years. In South Africa, contractual adjudication is well established and it works very well. Although the adoption of adjudication in non-FIDIC projects elsewhere in Africa has been slower, the appetite for adjudication seems to be increasing. One example of this is the new edition of the Kenyan JBCC Green Book, for example, and now introduced adjudication, or is going to introduce adjudication as an interim method of dispute resolution. So we think over time, adjudication will become adopted across a broader field in Africa.
Thank you very much for that, Johan. That was great. I don't know. I think we have time for a few questions, which we're just going to put to the panel generally. One of the ones has been posed by Matt Malloy, which I think actually sort of applies to everything we've talked about today. So his question is, does the panel think that the time has come for a United Nations International Trade type convention for the recognition and enforcement of adjudication decisions? Or alternatively, would an amendment to the New York Convention to incorporate adjudication decisions in order to have the same effect? Well, Sean's put his hand up, so maybe that's to tell me we've run out of time. I'm not sure.
Hi, Jessica.
Hi.
I was going to try to address Matt's question myself after your panel session, but I'll check my thoughts out there and then the panel can respond to it. I don't think that adjudication is a defined concept internationally. So if we just look at the common law countries with adjudication, they're so different. They have so many different grounds for challenging in their own systems of enforcement. I think it would be wrong at this point. It's certainly something that we can try to work towards, but I think it's premature, and I'll leave it there. Thank you.
I think I would agree with that, Sean. It's one of the problems we have with the word adjudication is that it means completely different things every time you cross a border. Even within Australia, every time you travel from one state to another, you've got a different scheme. So I think we've got to be quite careful about that. I think the other thing with an international enforcement regime is it really appropriate to have that type of thing for something which is intended to be an interim decision, which is going to be challenged later if necessary.
Well, if I may just jump for a few consideration on the matter, I think it's an interesting question, but it will definitely need local legislation to be ready for that amendment, because it's not only, it doesn't finish with ratifying a convention. You need to adapt your legislation to the concept. So if there is no intention for such concept to be put into legislation, it will be difficult to ratify the amendment and or the new convention in any event. However, with one perhaps reservation, there may be some regulation about final and binding decisions, which are very rare, because I'm aware that for example, in my jurisdiction, it will be considered differently from the legal perspective as well, from just interim and binding decisions of the adjudicators. So just these two comments.
Thank you. Thank you, Yasemin. Sean, yes. I don't know if that's your hand up from last time or whether you've got something else to add there.
Sorry, hand was up from last time.
Oh, was it? Okay. All right. Have we still got a bit of time left there, Sean?
Yeah, you have. Yeah. I don't know if
Brilliant.
there's any burning questions you've got for the.
I mean, another point I wanted to.
Jess.
Yes, Glenn.
Even if we thought it was a good idea to include adjudication in the New York Convention, just think about how a receiving country, if they're not used to the procedure, the existing grounds, excess of jurisdiction, the procedure not in accordance with that agreed by the parties, public policy, or a party unable to present their case. I'm not sure if you want adjudication to be fast, sharp, if you'd achieve that through trying to enforce through a New York Convention with those grounds, which applied to an arbitration are very hard to bring yourself within, but might not be so difficult with an adjudication that's run over a very short period. Don't know.
Yeah, I agree with you. I agree with you there, Glenn. I've been looking at the chat that has been going on throughout the course, and there's been a lot of debate about mediation and its status, and whether it should be binding, whether it provides the justice that Peter was talking about at the beginning of this talk. And it's really my own question, but looking at the FIDIC conditions of contract, for example, perhaps dispute resolution boards are the future, which I put to the panel and say, would that give the parties the justice that it seeks without it having to have the uncertainty and time and expense of proceeding through whatever court the jurisdiction dispute is in? Silence.
I'll just address that very briefly, in the sense that, and it's more with a question in reply, Jess, but we have in Hong Kong government contracts now a process called Dispute Resolution Advisor, which is not a dispute board, but they're kind of related. It's a one-person standing dispute advisor, and it is proposed, as I understand it, at least, that at least some public sector contracts under this new adjudication scheme are going to continue to have the dispute resolution advisor as well as the adjudication provisions. So it will be interesting to see how those two systems work together. The intention will be that the dispute resolution advisor should help the parties to avoid getting to the point where they have to serve an adjudication notice. But we will see whether that actually happens.
Hi, Yasemin.
Yes, I'm very sorry to jump again, but it's a very interesting topic, and I have been involved in a few discussions about the topic as well in the past. So my approach to this is the following. Of course, adjudication and or dispute boards, more specifically, are not there to provide natural justice. As you have stated, it's a rough justice. So they are not there to replace arbitration and or the jurisdiction of the national courts, unless, as I stated, there is a final and binding decision. But it may be, in that case, that the parties actually agreed on the matter. So when you have a final and binding decision, yes, the matter cannot be reopened by the arbitral tribunal. However, it would also mean that the parties actually agreed on that, or negligently or purposefully. So that's the first thing. And the second thing is that, as I have stated in my speech, it is not there to replace, but it is there to provide a panels which is very experienced and expert in their areas, rough decision and or opinion on a matter, which is closely following the project from the outset. So although it is rough, it is also quite to the point and real time, and also coming with an expertise in the background. So that's all.
Thanks, Yasemin. I mean, you're absolutely right. There's so many advantages to resolving disputes early and cost effectively in terms of especially project work, which we do, and the bigger picture and keeping the project moving. It might not necessarily be applicable to every type of dispute, which is why I think adjudication has worked so well for construction, but perhaps not so well when you look at it in the professional negligence sphere. For example, here in this jurisdiction, it hasn't been picked up and run with quite at all, in fact, in the same way. Peter, over to you. You've got your hand up there.
Yeah, I was just going to say two things. Firstly, in terms of just standing dispute boards, I think there is an issue with the same person or people holding your hand throughout a project and advising you and taking those sort of interim decisions, then being the arbiter in a binding decision, because there is a possibility for bias with the best will in the world. So that's point one on that side of things. I think to Yasemin's point, I agree, adjudication is not set up to be the perfect solution, and nobody thinks it is. The problem is I don't know what the stats are, but let's call it 60, 70% of the time, maybe even 80, a lot of this stuff doesn't get beyond adjudication. You may well have spent on a 3-month process 100 grand. You might have paid your adjudicator 50 grand. For all but the biggest projects, you may well lose the appetite or the resource to further fight it. So in most cases, it does ultimately create the ultimate decision, even if it's not intended to.
Thanks, Peter.